Well, howdy there, folks. James from politicalfriar.com coming at you again. I got the law hat on, so we're going to talk about a legal topic today. I want to revisit whether or not Section 3 of the 14th Amendment has any effect on Donald Trump's eligibility to run for president of the United States again. And this has come up recently because we have a guy named John Castro who's running for president, not really running for president, but running so that he has standing to file this legal claim. The argument goes that Section 3 of the 14th Amendment disqualifies Trump from being any kind of officer of the United States, president included, because he gave aid and comfort to the insurrectionists that were attacking the Capitol building on January 6th. And the the legal argument has caused a stir. There are law professors who are on both sides of this one, and there are court cases that are grinding their way through the system making this claim. And I'm talking about it today recently because John Castro lost recently. He lost at the lower court, and the lower court says no, the 14th Amendment bar doesn't apply, and he appealed it directly to the Supreme Court, and we found out today that the Supreme Court's not going to take up the case. They didn't grant cert for it. And that doesn't mean that they won't ever get there, because, of course, the appeals courts have to hear Castro's case, and if there ends up being a split among the appeals courts, then it could end up back in front of the Supreme Court, and there could be a split. Castro has filed this case in a number of jurisdictions, meaning that a number of appeals courts are going to have to weigh in on it. And so it might end up getting to the Supreme Court soon. Similarly, in Minnesota, the Minnesota Supreme Court refused to hear this case too. They kicked the ball down the field, punted the issue, saying, "Well, it's a primary election, so we won't talk about it until Trump wins the nomination and he's on the general election ballot." But that is another forum that could cause the Supreme Court, the U.S. Supreme Court, to have to intervene, because when the state Supreme Courts interpret the Constitution such that it causes something this drastic, such as striking down a law or removing a political figure from being able to run for office, the U.S. Supreme Court's going to have to get involved. Another way that this gets there is through the number of trials. There's one in New Hampshire and one in Colorado asking the same question. And so, does the 14th Amendment bar Trump from running? I don't know. Let's get into it. First, let's read this disqualification clause. Section 3 of the 14th Amendment provides, quote, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in resurrection or rebellion against the same, or given aid and comfort to the enemies thereof. But Congress may, by a two-thirds vote in each house, remove such disability." Whew. The 19th century lawmakers really knew how to write clear as mud, didn't they? Well, okay, so in short, Section 3 says you can't be an officer of the United States if, one, you took an oath beforehand, and two, you broke that oath. That's basically it. It was put into place after the Civil War to prevent former members of the Confederate government from participating in the United States government. And that it was used repeatedly. There were a number of people who were disqualified under the 14th Amendment, Section 3, from being congressmen or being any officer of the United States in the 19th century. Now, this hasn't come up recently for a number of reasons. One, we don't get a lot of insurrections around here, thank goodness. Two, Congress passed a number of amnesties, and this is why I thought initially that the 14th Amendment wouldn't apply. See, in the late 19th century, as the Civil War faded into the background, Congress just passed a blanket amnesty. It says anybody who participated in a insurrection and would otherwise have been barred by the 14th Amendment, Section 3, you're off the hook now. So what about Donald Trump? Doesn't that get him off the hook too? Doesn't that mean that he doesn't have to worry about it? Well, no, I don't think it does. See, in a case actually around January 6th, in Amalfi versus Cawthorn, the Fourth Circuit actually rejected this argument. The Amnesty Acts didn't eliminate Section three's bar from office because they were retrospective, not prospective. It says anybody who is currently barred in 1890s, as of the 1890s, could run for office. But that doesn't mean it didn't keep going prospectively, and the plain language of the Amnesty Act really does make that pretty clear. So all those Confederate insurrectionists were off the hook, but future insurrectionists, maybe not. Now, that's not to say that Trump won't raise this argument, and he will, and maybe some judge will hook onto it as a way to sort of get around the problem, because the last thing that a judge wants to do is disqualify Trump from office. But let's assume that the Amnesty Acts don't get him off the hook. Let's see what other arguments he might forward. So first, we have to decide whether this applies, whether there was an insurrection, basically. So was January 6th an insurrection for Section 3 purposes? If it wasn't, then Trump's off the hook. Section 5 of the 14th Amendment empowers Congress to pass implementing legislation for the amendment. Therefore, Congress has the power to define an insurrection for the purposes of Section 3, but Congress hasn't done so directly. I mean, maybe it arguably has done so through the enactment of the Insurrection Act, and so a judge could use that language maybe to get him an idea of what we mean by insurrection for Section 3 purposes. So part of the Insurrection Act authorizes the president to call up the militia and armed forces in the event of, quote, unlawful, obstreperous combinations or assemblages or rebellion against the authority of the United States that make it impractical to enforce the law of the United States in any state by the ordinary course of judicial proceedings. Well, that kind of sounds like a crowd trying to disrupt the lawful execution of Congress's business, doesn't it? That does seem like an assemblage that makes it impracticable to enforce the law of the United States. So a judge could grab onto that language and say, yeah, this is an insurrection and Donald Trump is disqualified. The Insurrection Act also prescribes criminal penalties for insurrection. Anybody who incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid and comfort thereto, is to be fined, imprisoned, and barred from office. More clues for a judge to maybe decide whether or not this was an insurrection. How about the courts? How have they defined insurrection when they've been asked? Well, they have been asked recently. Like I said, good thing we don't have a lot of insurrections. But in 1894, a federal court in Illinois provided this jury instruction. Insurrection is a rising against civil or political authority, the open and active opposition of a number of persons to the execution of law in a city or state. It is not necessary that there should be bloodshed. It is not necessary that its dimensions should be so portentous as to ensure probable success to constitute insurrection. It is necessary, however, that the rising should be in opposition to the execution of the laws of the United States, and should be so formidable as, for the time being, to defy the authority of the United States. Again, kind of looks like January 6th, doesn't it? It says that it should be enough that it prevents the laws of the United States from being properly executed, and that's what happened. The Congress was forced to adjourn because of the violent actions of the protesters or insurrectionists potentially on January 6th. Other courts from around the same time defined insurrection similarly. I found no more recent examples to fit, unfortunately. So I guess we don't have insurrections often enough to build case law, like I said. This definition and those like it could still provide fodder for a future judge hearing a Section 3 challenge. But jury instructions from 130 years ago, that's a bit thin, don't you think? You might think that some of the January 6 cases that have already gone through the Justice Department would help, but none of the January 6 rioters have been charged with insurrection. So we don't have any decisions interpreting whether Congress has defined the term. We just don't know what insurrection means yet. So I can't say whether January 6th was an insurrection. But we do know that there's enough there for a judge to say it is. And we probably have enough there for a judge to say it isn't, thus setting up a split among the courts and possible resolution by the Supreme Court eventually of that question. But there's another question. Did Trump engage in the insurrection? Okay, so let's assume that January 6th was an insurrection for these purposes. If Donald Trump didn't engage in it or give aid and comfort to it, then he's still off the hook, right? So to be effective, Trump's words and actions have to rise to the level of give aid and comfort. So this issue is probably a fact question for the jury, and maybe we'll get a decision about this out of those Colorado or New Hampshire cases. But what question do we ask the jury? See, the judge is going to have to decide on that jury instruction. And the most recent attempt I found to try to define the idea of engage or give aid and comfort in Section 3 challenge was from Marjorie Greene. Marjorie Greene was challenged whether she was eligible to run for Congress in 2022 based off of her actions on January 6th. And so an administrative law judge heard this challenge to her candidacy and came up with this definition. So, engage includes overt actions and, in certain limited contexts, words used in furtherance of the insurrection and associated actions. Merely disloyal sentiments or expressions do not appear to be sufficient, but marching orders or instructions to capture a particular objective or to disrupt or obstruct a particular government proceeding would appear to constitute engagement. And then he went on to say that Marjorie Taylor Greene didn't do those things. But did Donald Trump do those things? If this definition lands in front of a jury, maybe the instructions to march to the Capitol and make your voice heard and, tell Mike Pence to do the right thing. Yeah, it's possible that a jury gets there with that type of instruction. It wasn't likely that Marjorie Taylor Greene did any of that stuff, but this wording is out there in the milieu, and if a judge decides to grab onto it, we might get a jury decision that comes out unfavorably for Trump. We could also get a jury decision going the other way. Juries are allowed to be unpredictable. That's part of the fun. Also note, this definition came from a state-level administrative hearing. It has no binding effect on the application of Section 3 for any judge. This is just the part where we have to admit again that we don't know what the law is. The judge who gets assigned the case is going to have to see how this process plays out. The next issue for this, and probably the best legal argument that Team Trump will make, and the one that if the Supreme Court decides that Trump is not going to be affected by this, is whether or not this Section 3 is self-executing. See, this question has come up in American history before, whether or not the Section 3 applies to ban people from office. And so remember how Congress arguably defined insurrection in the Insurrection Act above? Well, because we have no legislation that specifically addresses Section 3, arguably, Congress hasn't even taken the action required to implement the bar against holding office in the first place. Is Section 3 self-executing? Is it enough on its own, or does Congress have to pass some legislation establishing due process, who's the definition of insurrection, and all sorts of other things before you can even use Section 3? Indeed, that was the opinion in the one case that actually is directly on point. See, Chief Supreme Court Justice Salmon P. Chase in Ray Griffin's case from 1896 found exactly that. And responding to Chase's opinion that the Section 3 was not self-executing, Congress passed a statute allowing federal prosecutors to bring civil action to enforce Section 3. And that statute was repealed by the Amnesty Acts. And so it's not on the books anymore. So if we accept Chase's opinion, then there's no way to enforce this bar until Congress passes new enabling legislation. Thus, Trump is in the clear. Despite being Chief Justice, Chase's opinion also isn't binding. It was given in the context of a criminal appeal heard in the D.C. Circuit Court instead of the Supreme Court. Indeed, in 2022, a Fourth Circuit judge wrote a concurrence firmly rejecting Chase's reasoning. But in the same summer, a judge in Arizona accepted Chase's reasoning. We just don't know. It's a good argument, and if it is the case that Trump is off the hook, it's probably going to be something like that. And that's kind of a cop out, in my opinion. You can read Section 3 and see exactly what its command is, and other parts of the Constitution do not require enabling legislation to come into effect. And indeed, the vast majority of the 14th Amendment doesn't require any enabling legislation. The 14th Amendment's been interpreted by the courts, not by a Congress. So I think that Chase copped out on actually making a decision on it, and I think that the Supreme Court might do the same thing for probably similar reasons. It's because politics really shouldn't be this affected by the judiciary. So it's tortured, isn't it? I'm not going to address some of the more obscure arguments Trump might raise because they share the same issues with the arguments above. They're just not tested. We can't predict what a judge will do with them. The next question, though, is practical. Is it wise to go after Trump's campaign using Section 3? I gotta say, no. Chase's reasoning in Ray Griffith's case is as tortured as his critics claim. He basically backfilled a legal argument to accomplish his goal, but in fact, that's probably what needed to happen there, and it might be what needs to happen here. Chase reached for a legal way to not enforce the bar for the same reason that Congress later passed the Amnesty Acts: peace. Barring somebody from office because she's younger than 35 is easy enough to understand for the public to accept it. Barring somebody for engaging in an insurrection when neither of those terms is well defined, and lots of folks don't think that that was an insurrection regardless of the definition, well, that's risky. If a group of people feels the law is unfairly standing in the way of them exercising their right to participate in the democratic method of selecting their leaders, then hey, that group might decide the law isn't worth respecting at all and might seek alternate ways of selecting leaders, like insurrection. Trump's supporters are, unfortunately, too numerous and too willing to do violence for me to be comfortable applying Section 3 to him, even if it does apply from a purely legal perspective. I mean, arguably, Trump ought to be banned, but only arguably. And in that argument lay too many opportunities to do damage to the very fabric of our nation. This, in my opinion, is not the hill for those who oppose Trump to die on. Instead, listen. Win the election. Anyway, if you think I'm wrong about any of that, leave me a comment down below. I'm more than happy to engage in any in discussion that we got. Hit like to this. Make sure that you subscribe so you get my future videos and we can have some more arguments as we go. Anyway, I really appreciate it.